in an interview and you can make them say things that then you can go, aha, you really have committed the crime of the century, which is having a bad thought, or certainly not a thought that, I don't know, don't most of us, about 99% of people in this country, know that you can't change sex. And the reason that women like Jennifer Swain are having to go out and put stickers is because Wales in particular, they've decided you're not allowed to talk about it. The conversation's already been had. It's all been had behind closed doors. And actually, men can be women. Women can be men. We can talk to kids about gender identity. It's an absolute done deal without the consent of the public or even a conversation with the electorate. They have made these decisions. And so women like Jennifer, all over the world, actually, women like Jennifer are putting stickers up in protest.
However, I think what Jennifer Swain's worried about, and I'm very worried about this, is cases like that Karen White person who was jailed as a man, identified as a woman, was transferred, by the way, had a history of sex offences against women, was transferred to a female jail, whereupon she, I have to call her she, proceeded to rape 2 inmates. That's the sort of thing that worries me, and I think that's the sort of thing that worries Jennifer Swain.
This is happening in the USA. They've already transferred men into women's prisons. They've raped everybody, and there's hundreds of not hundreds, but there are tens upon tens of women right now that are suing the government for putting men rapists into their jail cell.
100%. Look, what you can't transition out of is the criminality of being male, and so there's no difference between the risk of a man, whether he calls himself a woman or calls himself a man. He's still equally a risk to women. Now, we know that that's quite rare because we know that there aren't that many violent assaults in comparison to the population of the UK. So we're not saying that every single man in the country is a risk to women. We're saying that some are, and it doesn't matter whether that man calls himself a man or a woman. And more importantly, what on earth are the police doing? I seem to think now that they police by political will and not by consent. And I think that is a really frightening episode for all of us. The thing that happened to Jennifer Swain, and I'm laughing because it's so crazy, they got a warrant to search her house for stickers. I mean, I can't imagine ever that I thought I would say those words about something in the United Kingdom, that the police got a warrant to search somebody's house for stickers.
When she's saying stickers, she's talking about posters that she's putting out.
And confiscated a book at the same time.
What it's leading towards, clearly, they think they might be able to get her for a hate crime. And what worries me about this is, it doesn't matter what I think, but whatever I do think, I've got the right to think it, to believe it. And I think you and Jennifer Swain have got the right to believe what you believe. Why can't you say that? That, in my view, someone born a man cannot become that. That's an infringement.
100%. I've been interviewed twice under caution. Once I was interviewed here in Wiltshire by 2 police that came down from West Yorkshire Police. They spent a night in a hotel to interview me under caution about 6 tweets in which I supposedly misgendered someone. That means I called a man. I said Mr. for a man, and I said that I thought it was abusive to castrate a 16-year-old boy, which apparently, this is the place that we are. We can't say things, really straightforward things about things that we know, if it's got anything to do with LGBT and mostly T. So if it's got anything to do with transgenderism, we're in a place where women simply can't speak the truth, or anybody can't speak the truth about what they see in front of them with their very own eyes, because you could be accused and prosecuted for a hate crime. I mean, I just think you can't start policing people's thoughts. That really is the road to hell.
Exactly. Someone born a male transitions to female, and they want to be called she. I mean, I don't see why we don't keep them happy. Whatever makes them happy. Why won't you concede that if it makes them happy, you'll call them she?
Well, I won't, because I think it is the first step So the reason that we are having difficulty having these conversations is because we have to use female language for men. And as soon as you use female language for men, you get into a whole world of trouble where people don't really know what you're talking about. So if you say about a trans woman, if you decide a man can be a subset of women, like in the case of Karen White, then it becomes a much more difficult conversation to say that that man cannot go into a woman's prison. It's the same as what's happening in American sports. There's that Leah Thomas, who's a swimmer, who is now competing, changing with women, who are making them feel uncomfortable. And it's all because we have used this nonsensical term of trans woman for a man. And so that's why I will not concede a single little bit of women's language.
I know you won't.
In Canada, there is a news story that is very interesting. It is about a father, goes by the name of Robert Hoogland, is how I think I say his name, who was put in jail, after referring to his biological child as his daughter. Your head might be spinning right now. What are you talking about? Well, we're going to break down this story. So this article comes over from the Post-Millennial. It says, there's a man in Canada who can only be alluded to as he who shall not be named, Robert Hoogland. For the sake of natural justice, it is important to speak his name. He is now Canadian State's prisoner of conscience. The warrant was issued by a judge after the arrest of a father after calling his biological female child his daughter and referring to her with the pronouns she and her. He was found to be in contempt of court. He is the father of a gender non-conforming biological female 14-year-old who identifies as transgender and prefers the use of male pronouns. Hoogland has repeatedly called this person his daughter, though the court has forbade it. So the courts in Canada, apparently, are getting involved in these things now for a 14-year-old. All right, so on Tuesday at 10 a.m. Vancouver time, Hoogland surrendered himself to the court in response to the Attorney General of British Columbia's warrant for his arrest for contempt. He was arrested and jailed. The warrant was issued by Judge Tamin on March 4th, 2021. The father opposes the child's undergoing, quote, gender affirmative medical procedures and has stated this opposition again and again. In the hope of saving his child from irreversible harm, she's 14, the Canadian medical system, the legal system, and the child's mother press ahead with social and medical transition of the child.
Keep in mind, medical transition means they're going to give her puberty blockers, and she will be sterilized because of that. And, you know, having sex after that, we don't know. But definitely she's going to be sterilized.
Hoagland gave several interviews to several Canadian commentators. The broadcasts were suppressed by digital platforms. He was threatened with contempt of court proceedings. What kind of father would I be if in 10 years she's detransitioning and she asked me, why didn't you do anything to stop this? None of you stuck your neck out for me back then, he said. Canadian State has taken a drastically wrong turning by institutionalizing transsexual medical procedures for children, then imposing draconian constraints on free expression to conceal the full horror of what is being done. It seems unwilling to consider the implications of the decision in Kiera Bell versus Tavistock in the UK. In December, in the UK, the High Court handed down the decision in Kiera Bell's judicial review of the state's gender identity clinic in Tavistock. It held that children of 16 and under were incapable of giving informed consent to puberty blockers. The clinic had known for 9 years that puberty blockers were ineffective for psychological distress and harmful to physical health. It chose to keep that information from patients, public, and apparently from the court itself. Oh, wow. All right. So here we have a 14-year-old transgender boy applies for protection order to restrain his father, CD, from publishing or speaking and giving interviews about this case or about AB's personal and medical information. So this is in the Supreme Court of the British Columbia. This was back...
They're giving them, because they're not putting the real names down on these court thingies. They're calling them AB, CD, and something else. Probably EF.
On April 15, 2019, entered. We have a protection order. And listen, I do not practice law in Canada, in Vancouver. So we're just going to sort of go through this with that full understanding. So it's before Judge Marzari. Persons appearing. We've got some different lawyers. Looks like the rest of this is sort of blanked out here. This court orders that under the Family Law Act, the respondent, born in 1973, so this must be the father, is restrained from, number one, attempting to persuade this person, formerly known as that person, born on October 18, 2004, to abandon treatment for gender dysphoria. So as a father, he can't attempt to persuade her to abandon treatment for gender dysphoria. Number two, addressing the daughter, addressing the son, formerly known as the daughter, born on October 18th, by his birth name. So they have to use. I'm sorry. Okay, so he is restrained from. So let's back this up. So number one, he cannot attempt to dissuade her from going through the gender dysphoria treatment. Number two, he is restrained from calling the son now by his birth name as the daughter. See why this is getting a little confusing. Formerly known as blank. As a girl or with female pronouns. So cannot use the birth name, which would have been female, and cannot use the pronouns as a girl or with female pronouns. Either to her directly or to third parties. So the court is telling this guy what pronouns he can use in Canada. Oh my gosh. This court orders that under section of the Family Law Act that this person, the father, born on 1973, shall not directly or indirectly through an agent or third party share information or documentation relating to the child, formerly known as the different gendered child, born, share information about sex, gender identity, sexual orientation, or mental or physical health status other than the following: his retained legal counsel. Wow. Retained counsel for the child. And the name respondents in the petition, they're filed at Vancouver. Okay, we got medical professionals engaged, cannot get information about it, or any other persons through written consent, without written consent of this person. Wow. Wow. Okay. So the court orders under the Family Law Act that there is that this person, respondent, shall not authorize anybody else other than his own retained counsel to access or make copies of files. Protection order expires on April 15, 2020. It's probably been extended, of course. Any peace officer having jurisdiction who has reasonable and probable grounds to believe that the respondent is in breach of these terms may immediately arrest that person and bring him to the judge of the Supreme Court to be dealt with. Signed off by the deputy in Canada, apparently, this person. Disobeying this order is a criminal offense, so it's just a straight protection order. So, okay. We've got the Supreme Court also out of British Columbia. Says this is a claim between A, B, C, D, and EF. Right? A, B, C, D, EF. So everything's being redacted and protected. Restriction on the publication. A publication ban has been imposed by orders of CD. Opposes this relief on the basis that the public attention that he brings to AB's case through interviews is essential to society and his right as a parent. He opposes the relief. The father opposes this because he says that his right as a parent. Father knows that child identifies as male, but does not accept the chosen gender identity. Nor does he accept this court's determination that it is in AB's child's best interest that he be acknowledged and referred to using his chosen gender identity. Finally, father does not accept the court's previous determination that using female pronouns and otherwise denying gender identity is causing harm. So father doesn't want to do it, says it's not harmful. CD says that an order of this court cannot change his beliefs in that regard. There is and should be no restriction on his right as a parent to express those beliefs to AB. Because this person's 14 years old. This child's 14. He's the father. AB's mother, EF, supports AB's application for a protective order. They share custody and guardianship of AB. They share it. AB filed a notice of claim, who is the 14-year-old, seeking to be found competent to consent and to proceed with hormone therapy. So a 14-year-old is filing a legal document. So let me just say this. In the United States, that person cannot even drive a car. That he's entitled to consent to medical treatment for gender dysphoria, permitted to bring this application under the Family Law Act, and Paragraph C, attempting to persuade AB to abandon treatment for gender dysphoria, addressing AB by his birth name, referring to the child as a girl or female pronouns, whether to him or directly to third parties, shall be considered family violence